I'd like to welcome you to today's event. I'm Caroline Fredrickson, the Executive Director of the American Constitution Society for Law and Policy, also known as ACS. ACS, for those of you who are new to this organization, is a national network of lawyers, law professors, policymakers, law students, and judges that promotes the vitality of the U.S. Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and rule of law. And we are so honored today to be joined by the Assistant Attorney General for Civil Rights, Thomas E. Perez. I think it's clear to all of us in the room how vitally important the Civil Rights Division is, and how critical it is for the division's leadership to believe that its mission is to advance civil rights. Since it was created in 1957, the division has played a pivotal role in upholding the civil and constitutional rights of all Americans, but particularly the most vulnerable members of our society. Every day, attorneys and staff work to enforce the federal statutes that address discrimination in education, employment, credit, housing, public accommodations, voting, and state and local government programs. In addition, they prosecute hate crimes, human trafficking crimes, and criminal interference with access to reproductive health services. Without question, the Civil Rights Division is instrumental in our nation's battles to advance civil rights. And because of this critical role, Attorney General Eric Holder has rightly called it the crown jewel of the Department of Justice. It takes a very special person to lead the Civil Rights Division. Tom Perez was educated at Brown University, Harvard's John F. Kennedy School of Government, and Harvard Law School. He has devoted his life to public service. He has worked in every branch of government and at every level, federal, state, and local, serving at different times as a career, appointed, and elected official. His background has given him a deep and broad set of experiences to draw from. I won't detail his entire background here. You have a handout that does so. But I will highlight a couple of aspects that make him particularly well qualified for his current position. Tom's first job after a clerkship was as a career attorney in the Civil Rights Division. He knows firsthand the work that the division does every day. He went on to leadership positions in the Civil Rights Division and then served as the director of the Office for Civil Rights at the Department of Health and Human Services. And most recently, he was the secretary of Maryland's Department of Labor, Licensing, and Regulation. In between, Tom served as special counsel to the late Senator Edward M. Kennedy for civil rights, criminal justice, and constitutional issues. And that's when I had the good fortune to get to know Tom. He was then elected a member of the Montgomery County Council in Maryland. And I have to admit that I also had the good fortune there to be one of Tom's constituents. To top it all off, Tom was a professor for 6 years at the University of Maryland School of Law and taught at George Washington School of Public Health. In the history of the civil rights movement, there have been times of hope and times of despair, periods of progress and periods of terrible setback. That has also been true for the Civil Rights Division. But the pendulum has now swung towards hope and progress, in good measure, thanks to the leadership of Tom and his outstanding team in the Civil Rights Division, as well as the perseverance of the career employees who carried on the work during good times and during bad. So it is a real special honor for the American Constitution Society, for me, to be joined this afternoon by Assistant Attorney General for Civil Rights, Tom Perez. Please welcome Tom.
Thanks so much. Thank you. Carolyn, thank you for that very generous introduction, and thank you for the opportunity to speak here today at ACS. The local elected official in me wants to tell you when it snows tonight, I'm not sure I can help you with your snow plowing, but I will do my best to direct your calls to the attention of the Department of Public Works in Montgomery County, but not my lane anymore. I can't tell you how remarkably fortunate you are at ACS to have Carolyn at the helm. Lisa Brown, Carolyn Fredrickson, it's not difficult to figure out why this organization in such a short period of time has done so much in so many different areas, and I wanted to thank you. I want to also thank you for your journal. I read it. I especially read the article regarding the Civil Rights Division from Senator Kennedy, and I'm very, very grateful for the commitment and the contributions that you have made. It's really, for me, a pleasure to be here marking about 70 days on the job to give you a report on what I've learned and where we're going as a division. And it's so appropriate to do this with the ACS because I actually looked at your mission statement, and it says to promote the values underlying our Constitution, including individual rights and liberties, and to being a force for improving the lives of people. And when I read that, I thought to myself, well, that sure sounds a lot like what the Civil Rights Division does as the moral compass of our nation. And so I want to thank you again for this opportunity. You know, in 60 short days, I've had a real opportunity to ponder the state of civil rights in the 21st century. In life, we've never stopped learning, and I've learned a great deal in these 2 short months. I've learned, for instance, that there are some in our nation, remarkably, who believe that we no longer need a civil rights division. There, in fact, is no denying the fact that we've made remarkable progress. You know, we elected an African-American president. We have a Latina on the Supreme Court. We really have made remarkable progress. But, you know, some believe that we can check off civil rights as something that's been done as a result of these accomplishments. But as I reflect on this, and I think you may agree, it really was not a culmination of our journey, the election of President Obama, but rather it was an important mile marker along the way. And I would ask those who believe that we have indeed reached the ideal of a post-racial society to consider the following set of facts. On the very night that President Obama was elected, 3 men in Staten Island reacted to that election and that news by going out in their community and targeting African Americans to assault in retaliation for this election. Or we could consider the fact that while we indeed have a Latina on the Supreme Court, a source of great pride for everyone, the first press release that we issued during my tenure involved a guilty plea from a Louisiana man who couldn't stand the fact that Hispanics had moved in across the street from his house. So they shot into his house, made them flee, and then burned the house to the ground. 2009 in the United States of America. Should we tell those people, those victims and their families, that we do not need a civil rights division anymore? Should we tell the residents of Shenandoah, Pennsylvania, that we don't need a civil rights division anymore? Should we tell the African American and Latino residents of Los Angeles who tried to rent an apartment, were playing by the rules only to be subject to discrimination, that we don't need a civil rights division anymore? Should we tell the high school girls in Florida, some of whom nearly lost their chance to participate in high school sports, that their problems have been solved and the Civil Rights Division's intervention in their case means that we don't need a Civil Rights Division? On a personal matter, as the father of 2 girls getting ready for high school, I'm a big fan of Title IX. Should we tell the young people who are housed in substandard juvenile facilities in New York that we don't need a civil rights division anymore because we're in post-racial America? I often reflect on my friend and mentor, Senator Kennedy, and he reminded us with regularity that civil rights remains the unfinished business of America. And I could go on and on with stories of that nature. I've learned a number of other things, though, in the last 60 days, one of which, and people often ask me, Tom, what are your first impressions? And one of the things I tell them is that the more things change, the more they stay the same. One of the last cases I worked on before leaving the Civil Rights Division in 1999 involved the murder of a doctor who provided reproductive health services 2 miles from the house where I grew up in Buffalo, New York. And one of the first cases I got briefed on when I returned 10 years later was the murder of Dr. Tiller in Kansas. The more things change, the more they stay the same. People are still having issues with who won the Civil War. Crosses continue to get burned. They got burned 10 years ago. They got burned 40 years ago. And regrettably, they got burned a few months ago. And we continue to deal with all of these issues. I had assumed, naively it turns out, with the benefit of hindsight, that the issue of interracial marriage was an issue that we had put behind us. Thought we'd shut down that unit in the Civil Rights Division, only to learn 2 weeks into my tenure that there was a justice of the peace in Louisiana who did not think that interracial couples were good for Louisiana and therefore denied marriage licenses, apparently in the belief that people like our president are never going to get anywhere in life if they're the child of an interracial marriage. Sure set our president back, didn't it? I've learned a lot of other things in this job, not the least of which is that Hubert Humphrey was indeed correct when he said that the moral test of government is how we treat those in the dawn of life, our children, how we treat those in the twilight of life, our elderly, and how we treat those in the shadows of life. And we've made so much progress, but despite that progress, there are way too many people living in the shadows, and that is what the Civil Rights Division is about, transforming shadows into sunshine. All too many people with disabilities still living in the shadows, institutionalized when they could be living in community-based settings. All too many of our Muslim American brothers and sisters subject to post-9/11 backlash. All too many communities of color disproportionately affected by the subprime meltdown, by unscrupulous lenders using the corrosive power of fine print to tear communities apart. All too many LGBT brothers and sisters living in the shadows, trying to be judged in the workplace by the content of their character, but forced to confront discrimination. All too many children lacking quality education. All too many children who want to learn English, who cannot learn English because we have all too many school systems that have not provided the necessary services that are required by law. All too many newcomers like my parents who came to this nation seeking the same freedom and opportunity that our parents and grandparents thought and sought, and they find themselves the targets of hatred and bigotry. Too many people in the shadows. But perhaps I think the most troubling thing that I've learned through my service, both on the transition for the Obama administration and in the last 9 months as I prepared for this remarkable privilege for which I am ever so grateful to our President and to our Attorney General, is the precise facts of what took place over the last 8 years. Because I've had the opportunity to drill down and to see what happened. I've seen the eyes and the faces of the wonderful career professionals who toiled during the last 8 years, did their best, and did so much, but it was so difficult. And to see a division and a division leadership that treated the division like the buffet line at the cafeteria, where you pick what you want to do and you pick what you don't want to do. And the Civil Rights Division is not the buffet line at the cafeteria. We must enforce the law, all the laws, fairly, impartially, and aggressively. Consider these facts. During the last 8 years, there were very, very few pattern and practice cases brought in the employment context. Despite the subprime meltdown, the Civil Rights Division played no role in holding underwriters, holding servicers, holding other lenders accountable for the discrimination, notwithstanding the existence of the Fair Housing Act and the Equal Credit Opportunity Act. In the Clinton administration, the appellate section filed 643 briefs in courts of appeals. In the Bush administration, 424. The appellate section was forbidden from talking to other sections about case-related matters. Forbidden. Communication is pretty important, I learned, first week of law school. But communication was verboten. for appellate lawyers. Disability rights section in the Clinton administration brought 228 lawsuits compared with 126 in the Bush administration. The housing section in the Clinton administration brought 676 cases compared with 324 in the Bush administration. The voting section brought 35 Section 2 cases in the Clinton administration compared with 15 filings in the Bush administration. In the hate crimes context, in 1996, when I was still a deputy chief in the criminal section of the Civil Rights Division, there were 51 hate crime prosecutions involving 82 defendants. Fast forward to a decade later, 2006, 12 hate crimes prosecutions, 22 defendants. FY07, 14 hate crimes prosecutions, 15 defendants. Look at the data from the Southern Poverty Law Center. Hate crimes were going up. Look at the data from the Hate Crime Statistics Act. Hate crimes were going up. Look at the data from the prosecutions. Hate crimes prosecutions went down. And every year, when people like Michael Lieberman and others tried to advance the hate crimes bill, they were met with an administration that threatened to veto. I must say I wasn't surprised by much of this data. I rather expected it, but I was rather shocked in the hate crime setting because Ed Meese made hate crimes a priority. Brad Reynolds made hate crimes a priority. John Dunn made hate crimes a priority. George Herbert Walker Bush made the prosecution of hate crimes a priority. Bill Clinton made the prosecution of hate crimes a priority. And Barack Obama and Eric Holder will once again make the prosecution of hate crimes a significant priority. But you know what? Enough about the past. I want to talk here about the future, where we've gone and where we are going. I've learned that the next chapter is going to be, and already is, a chapter of restoration and transformation. And what does that mean? Well, let me tell you what it does not mean. We are not here to recreate the Department of Justice Civil Rights Division that existed January 19, 2001. We're here to create and restore and transform a division so that we can meet the challenges of today and tomorrow and beyond. That is the mission, in short, of the Civil Rights Division, and that is what our agenda of restoration and transformation is all about. And so what it involves is rebuilding some core competencies, reinvigorating our enforcement, recognizing areas where we haven't been involved, understanding emerging civil rights areas and civil rights challenges, and recognizing that we're not simply open for business, but we can and must and are doing business in different ways, in new ways, and in better ways than ever before. And with the vision of restoration and transformation in mind, I have spent the last 70 days listening to our wonderful career staff, listening to external stakeholders, and working with our leadership team to really reevaluate our agenda and move forward. And we've done a lot of things in this short period of time. First of all, we've restored the nonpartisan, merit-based, transparent hiring process for all attorneys. Go to our website, and you will see the hiring policy. And I am going to be calling each and every one of you to recruit you because we got 102 new positions in our budget. And so we're going to be moving forward. That is something to clap about. You know, budgets are moral documents. When I was on the Montgomery County Council, I always said, don't listen to what I say. Look at what we do in a budget. If someone tells you that issue X is a priority, I always say, look at the budget. That'll tell you if it's really a priority. And we had flatline budgets over the last 8 years in civil rights. And this president and this attorney general and this Congress came in and said, big part of the mission of restoration of this division is restoring the budget so that we can, again, pursue the agenda that we need to pursue of restoration and transformation. And so I am ever so grateful to our president and to our attorney general and to our Congress for their advocacy in that area. We have renewed our commitment to combating hate-fueled violence and are actively working on the implementation of the landmark Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act. And we've already made some measurable progress in this area. In the first 60 days that I've been on the job, We have already done as much hate crimes activity as was done in the entire fiscal year of 2006. And by the way, that was a leap year. And we've done as much as was done in fiscal year 2007. And we're going to continue to enforce vigorously the human trafficking laws, but we're not going to do it at the expense of hate crimes laws. We will continue, and we have redoubled our efforts in the area of disability rights. And under the leadership of Sam Bagenstos, and with some wonderful career leadership in our disability rights section, in our special litigation section, in our housing section, we have understood that segregating people with disabilities in institutions is every bit as wrong and every bit as illegal as segregating kids of color in schools that were all too frequently inferior. And so you look at our actions. Don't listen to my words. Look at our actions in the first 60 days. We've had cases, landmark cases we've gotten involved in New York State, in Georgia, in Illinois. And don't simply look at the cases. Look at the briefs that we're filing. Because in the old era, in the old paradigm of work in the Civil Rights of Institutionalized Persons Act enforcement, we all too frequently looked only at the question of, was the facility safe? Was it constitutional? And those are important questions that we'll begin to ask and we'll continue to ask. But the equally important question is, should people be in these institutions to begin with? And if you look at the Illinois letter of finding, if you look at the Georgia letter of finding, if you look at our involvement in New York State, if you look at our amicus brief in Connecticut, you will see that we are asking both questions. Should people with disabilities be in those institutions? And if not, why don't you have a comprehensive, effectively working plan for moving them out into communities? And those are the cases that we are involved in, and we will have many more, because this is a significant problem. And in 60 days, we have already done so much to transform our work in this area. We've also, in the fair lending work, I'm playing a very important, our division is playing a very important role in the Financial Fraud Enforcement Task Force. And we have committed significant new resources to our fair lending work. We've already settled in our fair housing work the largest Fair Housing Act case involving discrimination in rental housing in Los Angeles, California. The owner of the Los Angeles Clippers, Donald Sterling, was the defendant in that case. A $2.7 million settlement, the largest settlement in the history of the Civil Rights Division. From 2005 to 2007, there were 16 cases total brought under USERRA, which is the statute that protects service members from discrimination when they return to the civilian workforce. In the first 8 months of the Obama administration, we have filed 18 cases. So we have picked up the pace of our efforts to protect service members who are doing so much to defend our nation and then confront discrimination at home. We have dusted off our disparate impact theory. If the facts support the use of disparate impact theory, whether it's the housing context, the voting context, the employment context, we will use the disparate impact theory, because every court that has ruled on this has said that it is permissible to do so. And we are not the buffet line at the cafeteria anymore. Some people don't like that line because they eat everything at the cafeteria. That's Mark Appelhoff's family, but it was 5 boys. I couldn't do that. I couldn't eat all that stuff there. And so we are also ramping up our efforts in the voting context, recognizing that every 10 years we have so much additional work to do above and beyond the robust case law, the caseload that exists already. And we are making very, very significant preparations to ensure that during this next cycle of redistricting, that we are prepared and that we are actively enforcing not simply Section 5, but Section 2, Section 203, the Motor Voter Act, every provision. Because once again, the voting section is not the buffet line at the cafeteria. We will continue, for instance, to do and build on the very good work of the Bush administration in the Section 203 area. They pursued many, many righteous cases in that area, and we should give credit where credit is due. But that work will not be done at the expense of Section 2 or at the expense of Section 5 or at the expense of motor voter. We can and will do all. Again, as I said, transformation and restoration, that's what it's all about. And what transformation means, among other things, is recognizing these emerging areas of interest, areas where the Civil Rights Division may not have played a large role historically, but must play a role today. One such area is the area of civil rights and human rights, recognizing that we must set an example for the world. And I was very proud 2 days ago to testify along with Assistant Secretary Michael Posner from the Department of State at a hearing convened by Chairman Durbin in a subcommittee of the Senate Judiciary Committee on how the Civil Rights Division is fulfilling its obligations under several international human rights treaties. And we will be working very closely in the months ahead with the Department of State on what's called the periodic review. And what that means is that we will be convening town hall meetings along with the Department of State in which we will be evaluating what we are doing in the United States. We are holding ourselves accountable because we must set the standard for the world, and these hearings will enable us to figure out what is working well in the United States and what is not working so well, so that we can again hold ourselves accountable in this area. There are many criminal justice issues that have a civil rights dimension, and I applaud the Attorney General for his leadership in directing division components to review the racial profiling guidance that was issued in 2003. And we are at the table in discussions on racial profiling. We're at the table in discussions on issues of crack and powder and addressing the issue of the crack powder disparity, working very closely with the criminal division and other DOJ components to ensure that we address these issues. We're working equally vigilantly to ensure that our LGBT brothers and sisters can be judged, as I said earlier, by the content of their character. And the first hearing I had after my confirmation was to testify on behalf of the administration in support of the Employment Non-Discrimination Act. It took 13 years to pass the hate crimes bill. ENDA was introduced even earlier than the hate crimes bill, but I'm confident that 2010 will finally be a good year and the critical year for passage of ENDA. We recognize, I like ENDA too. And we've recognized how in the aftermath of 9/11 that we must be vigilant in addressing backlash issues. And we spend a lot of time with our Arab American and Muslim American communities ensuring that backlash incidents do not happen. I was recently in Los Angeles a couple Saturdays ago addressing the conference of a group of Muslim Americans, and we talked about the fact that we can never again fall into the trap of believing that we can either protect our national security or safeguard our civil rights and civil liberties. That is categorically a false choice that the Attorney General rejects, the President rejects, I reject, and we will continue to be vigilant in ensuring that we never fall into that trap as a nation. We must recognize that we're not simply the department's litigators, we are the department's problem solvers. When I was on the hiring committee 15, 16 years ago, we used to give out those brochures and they said, Department of Justice, the nation's litigator. Well, today we are the Department of Justice Civil Rights Division, the nation's problem solvers. We have many sections whose primary work is non-litigation in nature, and they do remarkably important things to ensure equal opportunity for communities, whether it's immigrants who confront discrimination because they have an accent or they're foreign looking, whether it's our coordination review section, working with our agencies to ensure compliance with critical Title VI obligations and other obligations under federal law. And so our role as litigator is now only one arrow in a multi-quivered arrow, or something like that. One arrow, one of many arrows in our quiver. And part of our transformation is transforming how we do and how we enforce Title VI. Deval Patrick used to tell me Title VI is the sleeping giant of civil rights laws. And when I worked at HHS and had the privilege of serving under Donna Shalala for 2 years, I saw that in action firsthand. And I grew to appreciate what we can do in the Title VI context. And so we've had many very productive meetings, internal to the division and external with stakeholders. And we are learning so much about the power and potential of Title VI. That sleeping giant is waking up, and that is a big part of our transformation as a division. Transformation also means taking partnerships to new levels and transforming our relationships with our sister agencies. We cannot possibly succeed in the Olmstead context, for instance, unless we involve the Substance Abuse and Mental Health Service Administration and the Center for Medicare and Medicaid Services at the Department of Health and Human Services. They're the money people. And money if we do not have the money with us, we cannot fully succeed. Similarly, 4 of the most remarkable words in the English language: affirmatively further fair housing, and we're working very closely with our sister agency at HUD and with many other alphabet soup of federal regulators to give meaning to those remarkably important words, transforming our relationship with HUD. Earlier today, some of our senior staff was meeting with the EEOC, a series of meetings that we've had there to develop a memorandum of understanding so that we can do joint enforcement, recognizing that when we work together, we can maximize the synergies of our agencies. That's what transformation is about. It's transforming relationships with sister agencies. It's training state and local agencies to recognize hate crimes so that they can prosecute as well as the federal government prosecuting hate crimes. It's making sure that U.S. attorneys' offices continue to serve as force multipliers so that all of the work that we're doing here can be assisted by U.S. attorneys. And it's making sure that our community partners, our nonprofit partners, can continue to be of remarkable assistance. And you look at some of the most important cases we've brought over the years. Many of them we've intervened in cases that you've brought. Many of them we've filed together. And we continue to do that robust outreach so that we can move in that direction. And we're also transforming the way we approach cases, because oftentimes the challenges confronting communities are multifaceted. I come from a medical family, and when you have multiple medical problems, they're referred to as they're referred to as comorbidities. You got a number of things going on. Well, there are a lot of communities across America that have a number of challenges that have emerged. And all too frequently, we have taken a rather stovepiped approach to confronting those challenges. We send one section out, or another section out, or sometimes 3 sections out in the same community, doing various work of enforcing their slice of the United States Code. And seldom do the twain meet, and seldom do the twain communicate, all too frequently. And so we need to understand what nonprofits have grown to understand, which is that oftentimes you need place-based approaches to problem solving. You need to go into a community with an interdisciplinary team of civil rights lawyers and investigators to look at the entire range of problems and challenges confronting a community. And that's precisely what we are beginning to do in communities across this country that are regrettably facing multiple problems of a civil rights dimension. And if the solution to the problem is we've got to bring in our sister agency at HUD, or we've got to bring in somebody else from another agency, that's precisely what we'll do, because we are the Department of Justice Civil Rights Division, the nation's problem solvers, not simply the nation's litigators. So that's what we're going to do. We have a very broad, a very ambitious vision. It's a very exciting vision. And I wake up every morning with a hop in my step because I am so excited to be here. You may be asking, and I'll close on this, but I must confess that as I read or was preparing for today, and I've been asked this more than once, I've had people ask me, well, Tom, this is great, this is ambitious, we're very interested in this, but how are you going to do all this? How are you going to avoid being the buffet line at the cafeteria? How can you enforce every law? And that's a very fair question. Well, here's the answer to me. First of all, more people. 102 new positions, thanks to the leadership of Eric Holder, President Obama, and the Senate. We have more people. Flat line over the last 8 years, 102 people, when added to a base of 715 people, gives you, that, even in Bob Dole's world, that's real money, and that's real people, and that's a real opportunity to make a difference. But it's more than just more people. We already have great people, and I am so impressed by the work of our career staff at the department, and they are so motivated and so excited. I'm a firm believer that if you want a job done well, give it to a busy person, and we're having a lot of busy people at our department. But they are motivated. And when you are excited to get up in the morning and say, I'm Tom Perez, I work at the Civil Rights Division, when you have a hop in your step, and we've spent a lot of time listening to staff and addressing their concerns, when you're a motivated staff, you are a much more productive staff. Another way we will accomplish what we do is to make sure that civil rights lawyers work on civil rights work. The appellate section, for instance, was doing immigration appeals for a good part of the last 8 years. There's enough civil rights work to go around. I don't think we're going to be able to do that anymore. We also will have more accountability. I think we can work smarter. And I've already described our partnerships, our stovepipe implosion initiatives, our partnerships with U.S. attorneys' offices, the force multipliers that they will be, our partnerships with others. And when you expand these partnerships, when you do things that you've never done before, when you do things in a way you've never done before, I think you can get a lot more done. So I am confident that when we have more accountability, when we have more people, when we have more motivated people, more excited people, and we have these partnerships, that we can, in fact, get the work done. If it hasn't dawned on you already, let me just say one more thing. I love this job. Okay? And I want to tell you why. I want to tell you why. My 11-year-old, we go to church here on Capitol Hill, and periodically after church we'll go to the office, and she'll run around, and I'll work for a little while. And she asked me a couple weeks ago, why do you work so much? And I said, well, I love my work. They pay me to do this. Doesn't feel like work when you love your work. And I love my work because I got a great boss in Eric Holder, who has called this division the crown jewel of the Department of Justice, and who has done everything we've asked of him. I love this job because I have a great president who has made civil rights a major part of his agenda of transformation of this nation. I love this job because there are remarkable people in this division who do remarkable work. I love this job because there are people like you in the audience who have been carrying the torch for so long, doing so much stuff. I love this job because you read about cases that just blow you away. Some of which just, you ask yourself, how could this be in the 21st century? Today's lesson, which I learned about literally only 3 hours ago, was a case in Alabama. A couple adopts a foster child, HIV positive, 2 years old. Father is undergoing chemotherapy for cancer of his own. They go on their big trip, and they're at an RV park. And the person who owns the park or runs the park somehow finds out that the 2-year-old is HIV positive and doesn't let him use the facilities. This is the 21st century, 2009. Week or so ago, a few racists down in South Carolina plead guilty. It's a father and son team. It's the second or third father and son team I've encountered in 60 days on the job. An African American is going to a restaurant to use the facilities, and they chase him out. One guy grabs a chainsaw, starts the chainsaw and chases him down the road. The other guy grabs the car that person was driving. It had been parked there, and they set it afire. Two white people come to the person's aid. They attack them. This is the 21st century. This is our work. And they pled guilty. This is why I love my job. And working with all of you, we will move forward. And we will make sure that this chapter of our history is the best one yet. So thank you, and I look forward to your questions. Thank you.
Just a quick announcement. Hi, I'm Alex Wohl, Director of Communications for ACS, and on behalf of ACS, I want to thank you for those inspiring remarks. Mr. Perez has graciously agreed to take a few questions, and just a couple of little things that you need to know. One, there's a microphone, so please wait for the microphone so that we can get your words as well as the answer on tape. And please make sure you note your affiliation, particularly if you're a member of the press. And finally, please, as in Jeopardy, make your question in the form of a question.
Yes, sir.
Bob Ritter, attorney with the Appiani Humanist Legal Center. Thank you very much for your remarks and putting the floodlight on many of these civil rights violations. I have one, though, that I believe the shadow is still there, and that is the government's treatment of non-believers. The government, for example, in Salazar versus Buono, is fighting to keep religious monuments on public property. I got a call today from someone in Delaware concerned about legislative prayers or council prayers. I get calls regarding holiday displays where atheist or free thought groups aren't being treated the same as others. What can your department or your section do to try and obtain neutrality or faithfulness to the First Amendment?
Well, we have a robust docket of cases involving discrimination against religious minorities, cases in the employment context, again, in New York City, for instance, against transit workers who were discriminated against because they wore a headscarf. Other cases in the employment context, RLUIPA cases in the housing context. We have Mazen Basrawi is one of my senior staff people in the front office, along with Eric Treen, who are working on issues of religious discrimination. And so we have a rather robust docket, and we continue to have very aggressive investigation enforcement. And if you have specific cases that you want to bring to our attention, I invite you to do so, and we'll take a careful look and apply the facts to the law and ensure that they receive the treatment they deserve.
Well, how about FFRF versus Hanover, Pledge of Allegiance case?
Well, I'm happy to take a look at all the cases that you want to bring to our attention. Yes, sir.
Hi. Hi, I'm Gerald Gilliard. I happen to be a board member of the D.C. chapter of ACS. Given what occurred with some of the U.S. attorneys and other employees of DOJ who, based off their political affiliation, were removed or had other problems, and relating to the issue of job satisfaction, would the DOJ ever consider permitting its employees to ever again be involved in, federal employee labor unions, where they could be members of those in order to sort of protect their rights?
Could you repeat? I heard the U.S. Attorney side of your question and the issue there, but I didn't quite hear the second half of your question, sir.
During the Reagan administration, at least this is what I understand, DOJ kind of sort of barred employees from participating in federal labor unions. Will that ever change?
Well, I met, oh my goodness, a couple weeks ago with representatives of bargaining units within the Civil Rights Division, so I'm happy to look into your question. But one of the first things we did on the job was to reach out to the, I think it's AFSCME locals who are representing the majority of folks in the Civil Rights Division who are part of a bargaining unit. So we've actually had a fairly robust dialogue, and they've been very helpful on a number of work-life issues that we're looking at. So I confess I'm a little bit surprised by your question as it relates to the Civil Rights Division, because we do have an active and robust union working there.
Yeah, Eddie and I'm president of, and I'm your friend, I'm president of AFG at HUD, where attorneys are allowed to organize, where professionals are allowed to, and Justice Department attorneys are not. And I'm wondering whether, as to that, whether you would allow, if attorneys voted to be part, whether you could work to allow attorneys at the Department of Justice to have the same rights that attorneys in other parts of the federal government, that is the right to organize and the right to collectively bargain working conditions.
The Justice Management Division is the component in the department that addresses issues of this nature. I haven't had any conversations with that division about this particular issue, and I'm happy to have a conversation with them. I haven't had any to date.
Josephine Harriet, I'm a DC chapter member. Can you hear me okay now?
Yes.
Okay. I did an internship in the Civil Rights Division during law school during the Bush administration, and I noticed that there were a lot of people who, and news reports confirmed this, that some people were hired into the department on the basis of their connections to particular causes and their political ideology. And what I observed was a less than heartfelt commitment to civil rights and the mission of the division. Have you, under your leadership, have you addressed that? Has that come up? And how do you bring these people along and help them to embrace the vision that you have for the division when they were specifically brought on in order to embrace and to further the agenda of the previous administration?
Excuse me. Sorry about this. That's my kids put the. You can put your own ringtone on it, and that's my 7-year-old. That's his ringtone. I thought I had turned it off. It says, "Dad, pick up the phone." He just wanted to participate. I told him I'd be here. You ask a very good question, and regrettably, the Inspector General report documented hiring practices that violated a number of provisions. And I had the good fortune of serving on the hiring committee under both Republican and Democratic administrations, under John Dunn and then under Deval Patrick. And I can tell you that their direction to us was identical: hire the best qualified people. And if you look at the document that's on our website now, that is the hiring policy for lawyers, and again, I encourage you to apply. That was a document prepared by the career staff for the career staff, and it sets forth in a very fair and transparent fashion what we will do. Now, as it relates to folks who are on board, frankly, it doesn't matter whether you came on board 4 years ago or 20 years ago. My philosophy is the following: we communicate expectations. This is what you have to do in this job. If you do the job and carry it out effectively, we want to have you as long as you want to be here. And if you don't do the job, whether you were here 4 years ago or 20 years ago, you will be held accountable. And the way to move forward on our robust agenda is, as I said before, to ensure that we have more people, more passion, more accountability, and that's what we will do.
Hi, Mr. Perez. Ryan Riley, a reporter with MainJustice.com. There was a story today in today's New York Times about certain Muslim groups being upset and thinking about not cooperating with the FBI because of their use of informants. I was wondering if you could speak about balancing national security interests with outreach to Muslim organizations, such as the group you spoke with a couple weeks back.
Sure.
Thanks.
Yes, that's a very good question. And we have a lot of contact with Arab American and Muslim American organizations. And I think, and one of the keys to the successful relationship that we have is when events occur, we have very good lines of communication. And again, we have issues that involve security, and we also have issues that involve post 9/11 backlash. And I think the key to the relationship that we've had so far has been a very open line of communication. I've participated in my office in 3 or 4 meetings, large group meetings with various organizations, and what we've done is we've brought all the components together. So they're not simply meeting with Tom Perez, they're meeting with the FBI, they're meeting with DHS, they're meeting with US CIS, et cetera. And I think those have proven effective. And are there challenges that come up from time to time? There's undeniably challenges, but the key to resolving these challenges, I believe, is to make sure that we communicate as best we can, and we're going to continue to do that. And when I was at the MPAC conference a couple weeks ago, one of the leaders there opined, and I was heartened to hear this, that the relative dearth recently of post 9/11 backlash incidents, he attributed in part to the fact that we have built this very good partnership, so that we have been very aggressively out there in communities talking about how, especially in the aftermath, for instance, of the Fort Hood incident, talking about how we are aggressively pursuing those incidents. One more? Yes, sir.
Hi, I'm Ari Shapiro from National Public Radio.
I heard you yesterday morning, I believe. You must be tired.
I was able to sleep past 2 a.m. this morning, thank you. In the past, the Civil Rights Division's practice has been posting significant cases that merit a press release on the website. And it wasn't until the GAO report came out that we learned the specific numbers of cases in the previous administration, and then you've cited the numbers for this administration. Would you consider posting every single case so that on a week-by-week basis we can see the progress that you've talked about and chart how many cases in each category have been brought, how many settlements, how many guilty pleas, not just on the cases that deserve a press release, but on every one?
I'm happy to take a very careful look at that, because we want to build systems that are as transparent as possible, and and our websites are a good vehicle for communicating that. So I'm happy to take a very close look at that. Great. Oh, yes, sir.
My name is Charlie Sullivan, and I direct a international prison reform organization. I think you know, being a councilman, that there are a lot of people going into prisons and jails. I think there are 13.5 million a year going in and out of jails. I think 4 million of the 13.5 million go in multiple times. We have 2.3 million incarcerated. Have you given any thought to having more outreach and access by prisoners to the Civil Rights Division?
Well, we're very much a part of the criminal justice policy group that the Attorney General has put together, and we're looking at a host of interventions that will, including the conversation about crack and powder, including conversations I've had as recently as this morning with Lori Robinson about reentry, and there are more reentry dollars in this budget so that we can address the cycle that you correctly refer to and ensure that we have systems in place that can hopefully prevent recidivism or reduce it as best we can.
What I was asking for the participants, though, that there be outreach that they have civil rights for prisoners, and also access to the Civil Rights Division, which we get letters every day, and their civil rights are violated. They do not know where the remedies are. They're very much in legalese, et cetera. How can we provide outreach that these individuals have civil rights, and secondly, that they can do something about them by contacting the Civil Rights Division?
We just completed, I believe it was yesterday, a trial involving an assault in a jail in Oklahoma City, I believe it was, Robert? And we've done a number of other cases involving violations that have occurred in jails. And then you look at the juvenile justice system in New York. We're involved in that. So I'm happy to entertain any suggestions about additional ways to get the word out. But we've had a fairly robust program of enforcement in the prison context, and we'll continue to do so. Because if the law is violated, we will hold the violators accountable.
On behalf of ACS, please join me in thanking the Assistant Attorney General.
Thank you.